Okay, today is Sunday, April 21st, 2013. This is a video statement under oath for settlement conference in Stockton, California for Judge Grill's settlement conference hearing. This is my statement due to the fact that I have a hearing impairment and I keep repeating myself, so I made a video statement. And the statement will be as follows. I appreciate it. If you hear it, it's entirely the complete tape. Thank you so much. Julio Zamora, 1385 El Camino Way, Los Banos, California, 209-829-1787. And this is a statement for Judge Grill's Settlement Conference in Stockton, California, Workmen's Compensation. Okay, this is Julio Zamora, 1385 El Camino Way, making a notation for trial. Today is Sunday, April 14, 2013. I should note for the fact that I've been sitting here since December 7, 2010, and I don't know why. I wasn't handed anything in writing why I was sent home, and I didn't work first and grieve later. And false accusations occurred on December 7, 2010 by the dispatcher, who changed the time on my logs by taking the time from the second time clock and changing the time on my logs from 10:30 to 11:15. And he's the only one with a key. He took the time from the second time clock. I should also note for the fact that he made a statement on December 7, 2010, the fact that he knew I was there at 10:30. The dispatcher made a statement on December 7, 2010, that he knew I was there at 10:30 at the beginning of my shift, which I'm already on duty at 10:30 in the morning, every morning automatic start. And then he turns around and he takes the time from the second time clock and he moves my 10:30 start time to 11:15 on my logs from the tractor. I don't know what the deal is here, but he made false accusation on December 7, 2010. And he interrogated me and told me that the sharpshooter was on his way after he finished his interrogation. I should note that I had a severe profound hearing impairment, and I don't know what he was saying. I can't make heads or tail what the heck he's talking about. But in any event, for trial, I want to note for the fact that the dispatcher falsified my documents, and I had it verified by a DOT official in the Highway Patrol's office in Los Banos, California. And I have a witness to that fact. It stated that my logs appeared to be altered or tampered with on December 6, 2010. So that's what happened. On December 6, 2010, the dispatcher took the time from the second time clock and changed the time on my logs, and he's the only one with a key. Okay, so I didn't falsify anything. I don't know what he's talking about or whatever, but I want to note that for trial. And I was supposed to work first, grieve later, according to the contract. It didn't happen. So I should have been working this whole time from December 7th, 2010, because of the fact I worked the whole year of 2010, and I received a notice of offer of work on December 1st, 2010. On December 3rd, 2010, I went to work, and on December 7th, 2010, he just flat out sent me home. Didn't work me first, grieve later, and he took my trip sheet or time card, whatever it is, from the tractor in which I log into on duty. It disappeared. I don't know where it went. But I do have the Allo rhythm sheet that shows that I was there at 10:30. I was on duty on time. So, and that's it. That's my statement for trial, and I'm going to state it under oath. So that's it. Today is April 14, 2013, and a notation for trial. Okay, today is Thursday, April 18, 2013. I'd like to make a notation for trial. An add on to the recording that I just played. I'd like to note for the record that I have logs in a tractor that I get paid by 14 hours a day by the miles. And then there's a second time clock in the driver's room that I don't get paid, the difference in miles or delay. I should also note for the fact that there's no doubt that it's a second time clock for the fact that, like I said in my prior recording, he took the time from the second time clock and he changed the time on my log, putting me in violation of the Department of Transportation. Now, if both clocks were running, if we were getting paid by both clocks, and both clocks were considered as one, why would he have to change the time on my logs? So I'm thinking that the second time clock has nothing to do with the logs in the tractor. So what that's all about, I don't know. But the point of this notation is the fact that I've been there for 10 years and I run out of miles and I log out in Livermore or wherever it is. I'm on the company time clock. I should be getting paid by the hour, and I'm not. In fact, it's not even being recorded on the logs. And I should also note to the fact that I'm in violation because I'm driving a vehicle from Livermore back to Tracy. Even though I put down the delay, sometimes they pay it, sometimes they don't. But you can count on the fact that the majority of the time they don't pay the delay. So I'm stating for the fact that if I'm on the company time clock, I should get paid by the hour. I should get paid by the hour. I should note that for the record, that there is in fact two time clocks. And there's 400 drivers that haven't been paid 10 years that I've been there, the difference in miles or the delay. Maybe 20 years, and there's 400 truck drivers that haven't been paid by the hour. Because when you log out of that tractor, you're getting paid by the hour. You're not getting paid by the logs. So there's no doubt he falsified my documents because I was logged out of my tractor. And then when I logged in, I have an automatic start at 10:30 every day for 6 months or however long my bid is. Now he takes the time from the second time clock, like I said on the prior recording, and he takes the time from that time and changes the time on the logs, which he's not allowed to do so according to the Department of Transportation regulation. 395.15 and 395.16 in the interpretation, and 395.8. And we're supposed to follow company policy and a union contract. You will follow Department of Transportation regulation, period. Well, that's what we all do. We do what we're instructed to do. But we're not getting paid by the hour when we log out of that tractor. Now, I don't know for sure, or whatever the story is, because I have a severe profound hearing impairment, so there could be a misunderstanding. But I don't believe it is, and that's where the court has to resolve this issue. The fact that it's safely running two time clocks. And why aren't the drivers getting paid the difference in miles or getting paid by the hour after they log out of that tractor? In which, when they log out of that tractor, they're required to go home, according to the Department of Transportation, and they're not allowed to do so, and they're on company time clock. They have to clock out. Or it's not logged out, they have to clock out, because you're already logged out. So, I'd just like to note that for the court. Due to the fact that I exhausted the union remedy and was unable to bring up the situation that's at hand, and the union hasn't done anything about it, and the fact that that they didn't follow contractor's procedures, and I wasn't able to stand up for my rights. And so I guess they just laid all this on workman's comp. And the fact that I have a hearing impairment and they're in violation of the Disability Act that was amended since 2000, amended in 2009 for the hearing impaired. I just want to bring all this up so that when it gets to trial, the judge can decide what the remedy really is or what it should be. But I like it included in trial, the fact that they have 2 time clocks and I haven't been paid for 10 years, and the fact that I don't get paid the difference in miles or I don't get paid by the hour. And the fact that I've been waiting here for a phone call or registered mail to be returned to work, and I should get all that back paid from December 7, 2010 for the fact that my trip sheet or logs or time card, whatever, disappeared. And I was on the second time clock. I should be getting paid by the hour, but they didn't pay me. And the trip sheet or time card disappeared, like I said in the prior recording. I don't know where it is, but I should get paid for that day. And so, and they should, I hope the court considers to enforce a notice of offer of work, and the fact that I was an FMLA, and Jesus Christ, man, I'm just sitting here, and I don't know why. I don't know why. So I hope the court considers double standards. Life is not fair. That's my recording concerning the time card, the second time clock. And today is Thursday, April 18, 2013. End of recording. Okay, today is Wednesday, April 10, 2013. I'm making a notation of the fact that I'm going to deliver 2 discs and a short statement for both attorneys to Modesto Legal Clinic, Modesto, California. I'm going to hand these 2 envelopes with 2 discs to Melissa, and to have one forwarded to Safeway Attorney. I should also note that tomorrow, Thursday, April 11, 2013, I will have all the documents in my presence. And if she could request any, I will have them there so she can make a copy to back up my statement. So, and that's about it. I just want to note the fact that they received the disc for my statement under oath in court, in Judge Rill's court in workman's comp in Stockton, California. And so that they're aware of the fact that I'm going to make a statement under oath, I'm going to play a video disc so they know. And at that time, they should produce any documents that they have to debate my statement that I'm making under oath, that they complied within within the time limits. The time limits, according to the contract, are in 10-day sequence. Okay, 10-day sequence. So in other words, they have to file a grievance for all suspension and discharges within 10 days. They have to file a grievance within 20 days. At the point they knew about the incident. So, in other words, what I'm stating here is the fact that they didn't offer or have the opportunity to go to Board of Adjustments, and all suspension and discharge or intent to suspend should be heard by Board of Adjustments, which never happened. So, in any event, and they never produced any evidence or within the time limits, or informed me of any intent to suspend, discharge, or whatever the disciplinary action is by December 25th, 2010. They didn't produce anything. In fact, they didn't do anything. Okay, so this is a notation that I'll have the documents, including the document that Local 439 Teamsters in Stockton, California received agreements stamped Local 439 received. Okay, on December 17, 2010. I should note that's more than 10 days. And that's my notation. I just want to make it clear that that both the union attorneys are informed of my statement under oath. Whenever I receive the court date, I should get a hearing date for settlement conference with Judge Grill very soon. He's been waiting for them to, I guess, to apply for a court date or whatever, but I've been sitting here waiting, and he has the legal documents for severe, profound hearing impairment. I'm partially deaf. So he's been waiting for them to come back because he ordered the legal documents and they're done already. So that's my notation for April 10, Wednesday, 2013. Let it be noted. Today is April 14, 2013. I got another notation for trial. I received a notice of offer of work on December 1st, 2010. On December 3rd, 2010, I went to work. On December 7th, 2010, made false accusations and flat out sent me home. And my trip sheet or time card, I have no idea what happened to it. It just disappeared. I received another notice of offer of work in 2013 from MORLES, Safeway Insurance. I should note on the first notice of offer of work, it was signed by Esperanza, Safeway Private Insurance in Arizona. So I received two notices of offer of work, and they did not comply. I received one in 2010 from Esperanza, and in 2013 I received another notice of offer of work from MORLES. In 2013, I like to note that for the record. And the fact that they don't wish to comply, and the terminal manager, James Williams, knows all this, and he doesn't want to comply with the notice of offer of work guaranteed for 1 year. And I didn't start one day on the 10 o'clock shift Eureka run. So I should note that for the record. Again, I hate to repeat myself. I received two notices of offer of work, and I've been denied to return to work at least 3 times. And I should also note that on December 7, 2010, I was supposed to work first and grieve later. It didn't happen. And also I should note that there was no representation. He told me to sit down. The shop steward's on his way. And just for the record, the fact that the dispatcher is the only one with the key. He took the time from the second time clock and changed the time on my logs and the tractor. When I got an automatic start at 10:30 in the morning, he changed it from 10:30 to 11:15, and he's the only one with the key to be able to do that, and that's the dispatchers. He falsified my logs and put me in violation of the Department of Transportation and company policy. So, okay, so this notation is all about receiving two notices of offer of work, and the terminal manager doesn't wish to comply. And they violated contractual procedures, denied me representation, and I sent a prescription for severe profound hearing impairment and the test results, and they denied me arbitration, and they put it in workman's comp's lap. I exhausted all the union remedy, whatever it is, I exhausted it. So there's no union remedy for my case, and they dumped it on workman's comp. They said they know that I have disability issues, and that was a letter stated by the union attorney. So that's my notation for Sunday, April 14, 2013.
Excuse me, iTunes needs your attention.
Oh, shit.
Okay, today is Tuesday, March 26, 2013. I want to make a notation for myself for trial. The fact that they didn't follow contractual procedures, that's one thing. Disciplinary action was denied, that was another thing, and they should have put me back to work like 1,500 Teamsters. I believe the reason they didn't put me back to work is because they don't deal with disability issues. I think that's what it is, because I send up a prescription and the test results for hearing impairment. So they were aware of the fact that I have a hearing impairment, and they denied me arbitration. Because the union probably, the company, Safeway, doesn't want to put me to work because I have a disability. And they probably going to deal with it in workman's comp. So the union just went along with Safeway. But the fact is, the union doesn't realize, I believe, that the Disability Act of 2009 was amended, and it included unions. There are no laws that discriminate against people that have a hearing impairment. And I'm stating for the record that they did. They discriminated against me by not returning me to work like 1,500 other Teamsters, that it was not filed in a timely manner, that it returned to work immediately. Now, the fact that the union doesn't handle disability issues is incorrect, according to the Disability Act that was amended in 2009, which includes unions on the hearing impaired. So I'm sitting here waiting for a phone call or registered mail, and it hasn't been done due to the fact that James Williams, the transportation manager, didn't fulfill his responsibilities. So I'm saying that he knew all what's going on, and he refused to comply with the Disability Act of 2009. So that's my statement for trial, and I believe that's what the problem is. The union will not deal with the hearing impaired, and Safeway will not put me to work because I have a disability, and the union is incorrect because they violated their contract by not working me first and grieve later, and let these issues be resolved in a time. And the fact that Mike Taylor didn't file in a timely manner also shows that the fact that they don't want to put me to work because of my disability, and they don't want to honor the notice of offer of work, which is good for 1 year, and it needs to be enforced. So I'm stating for the record that Local 439 Teamsters in Stockton, California, violated the Disability Act that was amended in 2009 for the hearing impaired, and that they're well aware of the issues, and they denied me arbitration. And when they did that, they violated the Disability Act of 2009 that was enacted by the United States Congress. So that's my statement. Okay, I'm just going to add this to the end of that recording. I'd like to remind the court the fact that when I was sent home on December 7, 2010, when I received the QME report on December 1st, 2010, it wasn't complete. The QME report was not complete because the doctor, I forgot his name, said that he doesn't do hearing tests. And I received that on December 1st, 2010. Like I said, a short story. I don't want to make a long story out of a short story. The fact is that the QME report wasn't complete. They offered me work for 1 year, and I needed it enforced. Because the QME report wasn't finished yet. They just flat out sent me home. And I'm sitting here, and I don't know why I'm sitting here. They violated all the time limits. They didn't produce any evidence of what my disciplinary action is to be or what it was by December 25th. And at least they had to put something in by December 28th, within 10 days. They didn't do so. They didn't do anything. They went around the Board of Adjustments, and that has time limits within 30 days. They didn't do that. They just didn't do anything within the time limits. And I don't know why I'm sitting here waiting for a phone call or registered mail to report to work when I have 200 employees underneath me. Now, James Williams, a transportation manager in Tracy, California, knows all this. He should have returned me to work like he does for 1,500 other Teamsters or 400 truck drivers. If it's not within the time limits, they're returned to work immediately. If it's not within the time limits, they're returned to work immediately. Now, I should note for the record in Administrative Judge Grill the fact that I don't know why I'm sitting here. They didn't produce anything. I never received any registered mail whatsoever of any suspension or discharge within the time limits. I did not receive one document of why I'm sitting here waiting for a phone call or registered mail to return to work according to the notice of offer of work that I asked for Eureka Run at 10 o'clock in the morning. And I'm still sitting here waiting. So I should get all that back pay because they didn't comply. 3 times they didn't comply. And I hate to keep repeating myself, but my life is on the line here. And I don't know why I'm sitting here. I don't have one document. Not one document for suspension or discharge, or the reason why I'm sitting here by registered mail within the time limits. Not one. And I'm still sitting here. So I should get all that back pay and benefits, and I hope Administrative Judge Grill returns me work according to the notice of offer of work that wasn't complete. They just flat out sent me home. And so I'm not going to go into it anymore about the deposition that I wasn't accommodated or anything else, and I need to take another deposition for the record. And that I have a new attorney, Modesto Legal Clinic, who took my case. Obviously, by my statement, you know why. The fact that Judge Bill didn't have nothing on the table, not my severe profound hearing impairment or the notice of offer of work. And that if it's at all possible, if Judge Grill could agree to the fact that Safeway should pay all attorney's fees and expenses to Modesto Legal Clinic for all their hard work and getting me to be returned to work. For the fact that Adam Stewart, I feel that he failed in his responsibility by not getting me a hearing test or not mentioning the fact to the Administrative Judge Grill that the QME report was not complete. And I didn't get paid every week or every 2 weeks. And that they're in conflict of liability with the EDD, Department of Unemployment. And he didn't mention one word about it since 4/17/2009 and ongoing. And I received another document from EDD saying that Safeway is in conflict of liability. I should be working. So with that being said, and the fact that Safeway doesn't want to comply, and it's just more time and money for Modesto Legal Clinic, who's representing me. And I don't feel I should have to pay Adam Stewart anything. So, but that's for you to decide what is fair and equal under the law. And your decision, I agreed to accept your decision, whatever is reasonable under the law. But I do request to go to trial to hear the case for the 202 Disability Act of 2009. Anyways, like I said, I have permission, or I was instructed to pursue this by the union attorney on workman's comp, and they're aware that I have a disability issues. I exhausted the union remedy. There's no remedy under the union to return me to work because I have a disability. And so they're not going to deal with it, and they threw it on workman's comp's lap. So, and the fact that I told them that I had a severe profound hearing impairment, and that wasn't acceptable, even though I sent them a prescription, and the test results to the union attorney. And it wasn't accepted, and they denied me arbitration. And so I, Julio Zamora, invoke double standards. Life is not fair. Okay, today is Friday, March 1st. Making a statement for Judge Grill Settlement Conference in Stockton, California. On 3/21/2009, I was injured on the job, and I went to see Nancy Perdillo, and she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. She's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. On maybe a week or 2 weeks later, I ended up in the Los Banos Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Perdillo for in Tracy, California. Drug and alcohol technician who said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is, I had a treating physician that I signed for good for 1 year. Paralosi, chiropractor. That if I get hurt on the job, that I'm to go to the company doctor for 30 days, and then the chiropractor is to take over. Okay, so and the Los Banos Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain, and that I have a low back, a pinched nerve. And I don't remember who I got the referral from, if it's Los Banos Memorial Hospital, what doctor it was, or if it was Dr. Yip or Paralosi. But they gave me a referral to Dr. Baby, and to fix the pinched nerve, it's a walk-in and walk-out type deal. And I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job related, the pinched nerve. And they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so because she's the one that said it was a sprain. So, okay, I haven't been paid every week or every 2 weeks disability payments since I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7th, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and grieve later. That didn't happen. They just flat out sent me home, and they made false accusations. And this is all disability related due to the fact that I filed in 2009 severe profound hearing impairment from reefer noise. Come to find out, at the settlement conference, Judge Grill's court suggested that I get a legal document for severe profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to be accommodated with a listening device because I have a more than a 50% hearing loss in both ears. And I should note also, for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing, and they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the shop steward, "Are you an authority on severe profound hearing impairment?" And Mr. Neiswanger, the BA from the Local 439 Teamsters in Stockton, California, which is a union shop. Was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that they didn't, Safeway didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits. Like they do for 1,500 other Teamsters, or return to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Niswonger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied and to send all proof, photos, evidence, whatever you have by December 25th to establish the fact beyond a reasonable doubt that Mr. Zamora did wrong or deserved disciplinary actions, and to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days, according to the contract. All Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with workmen's comp to work me for 1 year. And it was deemed accepted, whether I turned it in or not, and I had 20 days to comply or think it over if I wanted a change in job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I had 200 employees underneath me, and there was work available, and that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from Modesto Legal Clinic, because we were waiting for a document, to get a legal document stating that I have a severe profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home, and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me the shop steward is on his way, and he told me to sit down. And I was supposed to work first and grieve later. It didn't happen. And they just flat out sent me home. And again, I hate to repeat myself, but I have a severe profound hearing impairment. The panel hearing was put in abyss. And I told them, are you an authority on severe profound hearing impairment? And they just flat out sent me home. I had a settlement conference, and Judge Gill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work, guaranteed or work for 1 year, which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other Teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or a secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Miss or Mrs. Morles, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue, and that arbitration is refused, and that you could pursue it under workman's comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp's lap. So at that point, they didn't comply. They put it on workman's comp to comply, so I'm asking workman's comp to enforce a notice of offer of work, and I'm asking for trial, because I'm assuming the fact that they're in violation of 2009 Discrimination Act against severe profound hearing impairment or people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that, for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored. A medical, prescription drug, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%. So I don't know what the court wants to do about that, but I'm asking for it to be reinstated. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Nicewanger, on December 17, it was stamped, received, Local 439, on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also Step 1 and Step 2 of the contract, in which they didn't comply, and the union didn't enforce contractual procedures, let alone a hearing device or assisted hearing device at the panel hearing, and they put it in a bus and sent me home. So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013, and that everything to be restored, back pay and benefits and pension and RSVP. I don't make any payments. It's a premium lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it. and then I wouldn't have to make payment to the hospital. And the union put it on workman's comp to resolve these issues. They said I could pursue it under workman's comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010, changed the time on my logs from 10:30 to 11:15, taking the time from the second time clock. I should note that and put me in violation of Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. Tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before or corrected them, whatever the case is. I don't know what authority they have on changing logs. Under the Department of Transportation 395.15, 395.16, and the interpretation in 395.8, it states in there that they're not allowed to alter or change anything on them logs. If there's a problem, there's a right in the remark section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report. And that it states in there that I could do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Grill in the settlement conference to 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I lip read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids because I bought my own, and they're old, and they don't work at all. And I need something that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for trial, or for Judge Bill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work and return me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatments. I don't get paid every week or every 2 weeks since 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of offer of work. I hate to keep repeating myself, but I do have a severe profound hearing impairment, and my life is on the line. And I need the notice of offer of work to be enforced for the fact that my daughter needs 1 more year at the university to get her BA in biology,
one more year. I need that one more year. And they made an agreement with workmen's comp to work me that 1 year. And I'm asking for it to be enforced so that my daughter can finish at the university. And that was a guarantee for 1 year. And I didn't start one day on the 10 o'clock shift Eureka run. So I'm asking Judge Grill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for familiar situations or two different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Gill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 Teamsters are returned to work immediately. Well, they didn't put me back to work. And James Williams, our transportation manager, knows all this. He knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 Teamsters or 400 truck drivers. I should note that for the record. And I should also note for the record that they didn't accommodate me with any listening device whatsoever since 2006. So I'm asking Judge Grill to consider this and to enforce a notice of offer of work because my life is on the line here and I have no lifetime medical, I have no medical coverage whatsoever, even though I paid for it in 2002. I paid $3,000 plus to cover for 5 years so that I could retire at any time. And I should also note to the fact that Safeway called the health and welfare and said I didn't work at Safeway. And that barred me from getting any kind of lifetime medical or asking them to keep me covered. That didn't happen. So, and the fact that the dispatcher who falsified my logs by taking the time off the second time clock, and they have a no-fault attendance policy, and they applied it to everybody else, but they didn't apply it to me. No-fault attendance policy that's been as part of the company policy for 10 years that I've been there, and from my understanding, it's been on there for at least 20 years. No-fault attendance policy. So, and the fact that I never received any registered mail or anything else stating that I didn't work at Safeway at any time, not within the time limits. Okay? So, and the fact that they just flat out sent me home. And they didn't pay me on December 7, 2010. He took my time card or my trip sheet or whatever it is and disposed of it. I don't know where or when it disappeared, and I never got paid for that day. So that's why I'm asking for back pay from December 7, 2010. And I hope Judge Gill considers again to enforce a notice of offer of work and that to send this case to trial. And I will hope he considers this seriously for the fact that I have a hearing impairment and that the union should be held responsible under the Disability Act of 2009. And that's my statement for the court. Uh, so this is, so I hope Judge Bill considers the double standards.
Okay, today is Sunday, April 21st, 2013. As of to this date, they haven't returned me to work, and I've been sitting here waiting for a phone call, a registered mail to be returned to work, because the last words I heard when they took my security badge and asked for my seniority, and Mike Sadler just sent me home, and the sharpshooter said it was a safety issue. The last words I heard was, "I'm going to look into it." And they just sent me home and didn't work first and grieve later. The reason for this short statement is the fact that that if you get fired or you leave Safeway or whatever, you lose your lifetime medical insurance. I'm asking the court or asking Judge Grill to send this case to trial to resolve the issues of lifetime medical when a person has a permanent disability, hearing impairment, and that that I be protected and be returned to my job, and with all back pay and benefits, like I said in the last recording, etc., etc. That if the court decides to send me back to work, that I have some protection for my lifetime medical plan, RSVP under the Health and Welfare Fund, and that I'm not to lose it for life. I need some protection and to be returned to work. It's an agreement that was made with Safeway and the Teamster Union Local 439 in Stockton, California, and Safeway in Tracy, California, distribution center. So I'm asking Judge Grill to send this case to trial to decide the issue of the fact that I have a hearing impairment and that they took my lifetime medical plan away because I have a disability, a permanent disability. And I need some protection for my job and my lifetime medical plan. That that they can't allow to take it away, whether I get fired or whatever it is. If they return me to work, that I'm protected. And the fact that that they just flat out sent me home according to the notice of offer of work. And I need it enforced, and I need the case sent to trial to decide the issue of lifetime medical plan, because I have a permanent disability. And it shouldn't be decided by the union or Safeway, it should be decided in court. And they said I can pursue this in workman's comp. So I'm doing that. So again, I hope Judge Grill considers sending this to trial to resolve the issues of lifetime medical plan, and also to be returned to work with all back pay, like I said in the recording. I'm 73 years old, and I have 2 children in the university, so my life is on the line. So I, Julio Zamora, invoke double standards. Life is not fair.